Hi, my name is Akiva Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. When we talk about educating and informing the public, sometimes we're educating the public in that we're giving them a context for certain rules and regulations that come up, for certain things that happen, and sometimes we're giving more information. I'd like to spend a moment sort of in an educational contextual format and talk a little bit about terminology. If you trace things back to, let's say, the 50s, where custody was oftentimes given to the mom who had a preference because she was raising the kids, whereas the dads tended to be more in the workforce. So the court was, at that point, using certain language in its judgments of divorce. It would say, for example, someone has sole custody. Someone has full custody. There were certain terms that they would use. And when they talked about situations where the custody wasn't full, they might say the custody is joint, or they might say the custody is shared. The question is, what's the significance of those terms now? And sometimes we'll get the question, is full custody the same as sole custody, the same as joint custody being the same as shared custody? What is the significance of the variations of those terms? One judgment of divorce might speak to a joint custody situation. The other one might say it's shared between mom and dad. What do those words mean? Well, there was a time when it was important to ascribe certain definitions to certain words because those words would show up all the time and then they'd have to be interpreted. The court would have to have a ready definition for what it means to have sole physical custody. The court would have to be able to look at that and say, okay, this judgment says this word, and therefore this word means X, Y, and Z. Nowadays, the court is really getting away from the terminology relating to custody. Now, the court still has legal and physical custody, that's true. But in terms of splitting the hairs between what does joint custody mean versus shared, what legal rights and duties go along with one term versus the other, the courts are getting away from that. Now the courts are really not, a lot of courts aren't even putting any terms on it at all. They're simply saying the custody situation is as follows, and they're saying how many overnights with mom and how many overnights with dad. You can call it whatever you want. If you want to say that mom has 5 overnights a week and dad has 2 overnights a week, and you want to call that shared, albeit not in equal percentages, God bless. You can call it shared. You can call it joint. You can call it whatever you want. But the amount of overnights is what really dictates their rights and liabilities. For example, if it was truly equal, where we had 7 overnights one week, the next week the other parent had 7 overnights, we're going week on, week off, week on, week off, that would have an implication on, say, child support. Whereas if we're in a joint situation where dad has 5 overnights out of 7 and mom has 2, so it's joint, but it's not exactly equal, there's going to be an implication. If dad's got those 5 overnights, guess what? Mom's paying support based on the fact that he has more overnights than she does. It's going to come out that there will be a disproportionate amount of overnights to support a disproportionate support amount. So do the terms joint and shared have any legal significance at this moment in time? Probably not. There might have been a time when they did. It's not that important right now. What really is more important than that is a calculation of overnights. How many overnights for mom? How many overnights for dad? Now, if you have any questions about what your judgment says or what the implication is, let us know. Reach out. We'll be glad to help you out.